Hello! Welcome to the Study With Me series of Law School Buddy. Today's session will cover Part 6 of Person's audiobook series. Title 3, Rights and Obligations Between Husband and Wife. Title 4, Property Relations Between Husband and Wife. General Provisions and Donations by Reason of Marriage, under the Family Code of the Philippines, Articles 68 to 87. This is under the subject, Persons and Family Relations. I hope that this audiobook can help with your study and review. Let's begin. Title 3, Rights and Obligations Between Husband and Wife. Article 68. The husband and wife are obliged to live together, observe mutual love, respect and fidelity, and render mutual help and support. Article 69. The husband and wife shall fix the family domicile. In case of disagreement, the court shall decide. The court may exempt one spouse from living with the other, if the latter should live abroad, or there are other valid and compelling reasons for the exemption. However, such exemption shall not apply if the same is not compatible with the solidarity of the family. Article 70. The spouses are jointly responsible for the support of the family. The expenses for such support and other conjugal obligations shall be paid from the community property and, in the absence thereof, from the income or fruits of their separate properties. In case of insufficiency or absence of said income or fruits, such obligations shall be satisfied from the separate properties. Article 71. The management of the household shall be the right and the duty of both spouses. The expenses for such management shall be paid in accordance with the provisions of Article 70. Article 72. When one of the spouses neglects his or her duties to the conjugal union, or commits acts which tend to bring danger, dishonor or injury to the other or to the family, the aggrieved party may apply to the court for relief. Article 73. Either spouse may exercise any legitimate profession, occupation, business or activity, without the consent of the other. The latter may object only on valid, serious, and moral grounds. In case of disagreement, the court shall decide whether or not 1. The objection is proper, and 2. Benefit has occurred to the family, prior to the objection or thereafter. If the benefit accrued prior to the objection, the resulting obligation shall be enforced against the separate property of the spouse, who has not obtained consent. The foregoing provision shall not prejudice the rights of creditors, who acted in good faith. Title 4, Property Relations Between Husband and Wife. Chapter 1. General Provisions. Article 74. The property relationship between husband and wife shall be governed in the following order. 1. By marriage settlements executed before the marriage. 2. By the provisions of this code. And 3. By the local custom. Article 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of a marriage settlement, or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Article 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Articles 66, 67, 128, 135, and 136. Article 77. The marriage settlements, and any modification thereof, shall be in writing, signed by the parties, and executed before the celebration of the marriage. They shall not prejudice third persons, unless they are registered in the local civil registry, where the marriage contract is recorded, as well as in the proper registries of properties. Article 78. A minor, who according to law may contract marriage, may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement, subject to the provisions of Title 9 of this code. Article 79. For the validity of any marriage settlement executed by a person upon whom a sentence of civil interdiction has been pronounced, or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. Article 80. In the absence of a contrary stipulation in a marriage settlement, The property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply. 1. Where both spouses are aliens. 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located, and 3. With respect to the extrinsic validity of contracts entered into in the Philippines, but affecting property situated in a foreign country, whose laws require different formalities for its extrinsic validity. Article 81. Everything stipulated in the settlements or contracts referred to in the preceding articles, in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriages shall be valid. Chapter 2. Donations by reason of marriage. Article 82. Donations by reason of marriage are those which are made before its celebration in consideration of the same, and in favor of one or both of the future spouses. Article 83. These donations are governed by the rules on ordinary donations, established in Title 3 of Book 3 of the Civil Code, insofar as they are not modified by the following articles. Article 84. If the future spouses agree upon a regime, other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on testamentary succession and the formalities of wills. Article 85. Donations by reason of marriage of property, subject to encumbrances, shall be valid. In case of foreclosure of the encumbrance, and the property is sold for less than the total amount of the obligation secured, the donee shall not be liable for the deficiency. If the property is sold for more than the total amount of said obligation, the donee shall be entitled to the excess. Article 86. A donation by reason of marriage may be revoked by the donor in the following cases. 1. If the marriage is not celebrated or judicially declared void ab initio, except donations made in the marriage settlements, which shall be governed by Article 81. 2. When the marriage takes place without the consent of the parents or guardian, as required by law. 3. When the marriage is annulled and the donee acted in bad faith. 4. Upon legal separation, the donee being the guilty spouse. 5. If it is with a resolutory condition, and the condition is complied with. 6. When the donee has committed an act of ingratitude, as specified by the provisions of the Civil Code on donations in general. Article 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage, shall be void, except moderate gifts, which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as husband and wife, without a valid marriage. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. For more Study With Me sessions, please subscribe to our channel. Thank you so much for making us your law school buddy.